Criminal law. Strict liability. Strict liability crimes are crimes which require no proof of mens rea in relation to one or more aspects of the actus reus. For example, the offense of speeding. There is no requirement to prove the driver intended to speed or even knew that they were speeding. The act of driving above the speed limit is enough to make them liable. Strict liability offenses are primarily regulatory offenses aimed at businesses in relation to health and safety. Also, many driving offenses are crimes of strict liability. For example, not wearing a seatbelt or crash helmet, speeding, driving without tax, insurance or a license. The use of strict liability in criminal law is controversial. It may result in a person incurring liability where they are not at fault or have taken all reasonable care to ensure compliance of the law. However, the use of strict liability in criminal law brings practical benefits. Many of the offenses are dealt with administratively without the need for a court trial. It can provide a greater level of protection to the public in areas where it is perceived that there is a need to provide such protection. In determining whether an offense is one of strict liability, there is a general presumption that mens rea is required to impose criminal liability. According to Lord Scarman, in Gammon v. Attorney General of Hong Kong, 1985, the presumption of mens rea may be rebutted where 1. The crime is regulatory as opposed to a true crime, or 2. The crime is one of social concern, or 3. The wording of the act indicates strict liability, or 4. The offense carries a small penalty. There is some overlap with the categories in that where a crime is regulatory, it is often one of social concern and carries a small penalty. In such cases, strict liability should be used to promote the objectives of the statute and encourage greater vigilance to prevent the commission of the prohibited act. 1. The crime is regulatory as opposed to a true crime. Lord Scarman stated, the presumption of mens rea is particularly strong where the crime is truly criminal in nature. Where the crime is regulatory as opposed to a true crime, the presumption of mens rea gives way to a finding of strict liability. This was seen in Sweet v. Parsley, 1970. The defendant rented her house to students. Unknown to her, they were smoking cannabis in the house. She was charged with an offense of being concerned with the management of premises which were being used for the purposes of smoking cannabis. It was held that this was an offense which by its nature was a true crime and therefore mens rea was required. She was not liable. Examples of regulatory offenses which have been held to be strict liability include health and safety regulations. For example, pollution as seen in Alphacell v. Woodward, 1972, and the sale of unfit meat as demonstrated in Callow v. Tilston, 1900. In the case of R. v. Prince, 1875, the defendant was charged with taking a girl under 16 from the possession of her father. She had told him she was 18 and he believed her. His conviction was upheld as strict liability applied in relation to age. It was no defense if he held a reasonable belief that she was over the specified age. Strict liability applies to age-related sales such as cigarettes, alcohol, medicines as these are regulatory. However, the principle from R. v. Prince did not survive the decision in Sweet v. Parsley in relation to true crimes. In BVDPP, 2000, the defendant, aged 14, was charged with an offense of inciting a child under 14 to commit an act of gross indecency. He had sat next to a 13-year-old girl on a bus and repeatedly asked her to perform sexual acts with him. He believed she was over 14. The House of Lords held that where there was a charge of a true crime of gravity, the stronger the presumption of mens rea. His conviction was quashed. In RVK, 2001, a 26-year-old man was charged under Section 14 of the Sexual Offences Act 1956 with indecent assault on a girl of 14. His defense was that the sexual activity was consensual and that she had told him she was 16 and that he had had no reason to disbelieve her. The House of Lords quashed his conviction. There was a presumption of mens rea due to the gravity of the offense and provided his belief was genuine, it need not be reasonably held. 2. The crime is one of social concern. Where the crime is one of social concern, the presumption of mens rea may be rebutted. This is based on the assumption that strict liability imposes higher standards of care and provides greater levels of protection to the public. Crimes of social concern held to be strict liability include driving offences. For example, in R.V. Williams, 2011, the defendant was strictly liable for causing death by driving without a license. He was driving impeccably at the time and a pedestrian stepped in front of him. It was accepted there was nothing he could have done to prevent the impact, yet the offence was one of strict liability as he had no license. In Alphacell v. Woodward, the defendant was liable for the pollution to a river caused by a fractured underground pipe, despite being unaware that the pipe was broken. The crime was one of social concern, so strict liability applied. The sale of food is another area of social concern. In Callow v. Tilston, the butcher was liable for selling unfit meat despite having it certified as safe by a vet. 3. Where the wording of the Act indicates strict liability. The presumption of mens rea is rebutted by express provision in the statute excluding the requirement of mens rea. Where the statute is silent as to the requirement of mens rea, the general presumption remains. However, the courts may look at other offences created under the same Act. If the other offences expressly require mens rea, the courts may well take the view that the omission to refer to such a requirement was deliberate and that Parliament intended to create an offence of strict liability. This approach was taken in Pharmaceutical Society of Great Britain v. Storkwain, 1986, in relation to dispensing prescription drugs when presented with a fraudulent prescription. The pharmacist was strictly liable despite not being aware of the fraud. The approach was also applied in Cundy v. Lecoq, 1884, in relation to the sale of alcohol to a drunk person. The publican did not think the customer was too drunk to serve. He was liable as his assessment was not relevant as strict liability applied. 4. The offence carries a small penalty. Generally, where an offence carries a small penalty, this will indicate that it is regulatory as opposed to truly criminal in nature and therefore one of strict liability. For example, in the case of Williams, 2011, the offence of causing death by driving without a license was considered to be one of strict liability. The penalty was a maximum of 2 years imprisonment, whereas the offence of causing death by reckless driving carried a maximum sentence of 14 years. In summary, strict liability crimes are those that require no mens rea in relation to one or more aspects of the actus reus. There is a presumption that mens rea applies in criminal law. This presumption may be displaced if the crime is regulatory rather than truly criminal, if it is a crime of social control, if the wording of the Act indicates it is strict liability, or if the penalty is small. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.